Hello and welcome to this very special South Dakota Federalist Society student event. As some of you may know, my name is Anthony Leonardi, and I'm the president of the South Dakota Federalist Society. Today, we're honored to have with us Justice Scott P. Myren from the South Dakota Supreme Court. After his presentation, there will be an opportunity for audience members to ask him some questions. Justice Myren grew up on his family farm in rural Campbell County and graduated from Mobridge High School in 1982. He received a Bachelor of Science degree, double majoring in history and political science from the University of South Dakota in 1985. He earned his JD from Rutgers University in 1988, where he was the research editor of the Rutgers Law Journal. Justice Myren practiced law in Denver, Colorado, before returning to South Dakota to work as a staff attorney for the South Dakota Supreme Court. He served as an administrative law judge for the Office of Administrative Hearings and a magistrate judge for the 6th Judicial Circuit. In 2003, he was appointed as a circuit judge for the 5th Judicial Circuit by Governor Mike Rounds. He was reelected to that position by the voters in 2006 and 2014. In 2009, he was selected as a judicial fellow to the Advanced Science and Technology Adjudication Resource Center in Washington, D.C. In 2014, then Chief Justice David Gilbertson appointed him the presiding judge for the 5th Judicial Circuit. Justice Myren served as chair of the Unified Judicial System's Presiding Judges Council and president of the South Dakota Judges Association. He served on numerous committees, including the Court Improvement Program and Juvenile Detention Alternative Initiative, which he chaired. He also served on Governor Dogard's South Dakota Criminal Justice Initiative Work Group and Juvenile Justice Reinvestment Initiative Work Group, and he supervised the rural and urban pilot programs, which led to the implementation of Hope Probation across South Dakota. And in 2015, Governor Kristi Noem appointed Justice Myren to represent the 5th District on the South Dakota Supreme Court. With all that said, it is my honor to introduce to you all Justice Scott Myren.
Well, thank you. Good morning, or good afternoon, I guess. It's afternoon already. Thank you for coming. Thank you to the Federalist Society for inviting me to come and talk with you today. Just out of curiosity, how many 1Ls here? Quite a few. 2Ls? 3Ls? Others? There we go. All right. Well, welcome to you all. Most of the comments that I have are mostly directed at law students, but they could apply to anyone, and hopefully they will be helpful to you. In the fall of 1985, you heard I was a 1L at law school, and I remember trying to keep my head above water with all of the new jargon that I was having to deal with and all of the confusing new concepts. But I found that despite the fact that it was challenging, I really enjoyed law school, and I found it to be one of the most exciting times in my life. And it was a time when you start to think about what you're going to do with your life as far as when you finish law school. Although I had been a political science and a history major, not thinking back on it now, I realize I had very little knowledge about the legal system. I didn't really understand what it meant to be a lawyer, and certainly had no comprehension of the legal profession, had never really thought about it. I didn't even really know what lawyers did. I knew that my parents and my grandparents respected lawyers. I had had some interaction with lawyers in my youth, and I always respected them personally, but I didn't really know what they did. But there I found myself in law school, drinking from a fire hose, which I expect is familiar for all of you, but falling in love with the law. In that first year of law school, I had the really good fortune of being invited by a friend to attend a Federalist Society meeting. And he really encouraged me to come because they were inviting as their speaker a rising DC Circuit Court of Appeals judge who was rumored to be on President Reagan's shortlist for the next spot on the Supreme Court. His name was Antonin Scalia, and it wasn't a rumor. He was shortly thereafter appointed to the United States Supreme Court. He spoke with us about a number of different things, but in particular, what I remember him talking to us about was textualism. The idea that if you want to determine what a statute, what the legislature intended in the statute, you should look at the text of the statute, and you should not resort to the legislative history, which is what we have commonly done for a very long period of time. Judge Scalia was a captivating speaker, and he made me think early in my career about critically analyzing the cases that we were called upon to interpret in classes. And in particular, I started looking at how the cases, many of which dated back 100 or 150 years, how the courts in those cases had looked at statutes and whether it was consistent with the textualism approach that Justice Scalia, or then Judge Scalia, was suggesting was the appropriate way to do it. Now, I said he was a captivating speaker. I'm going to acknowledge to you that I am not a captivating speaker, but I was hopeful that I can give you some ideas of some things that will also cause you to think and maybe reflect upon your role as a member of our legal profession. So let's start with that concept. Have you ever thought of, I described for you, I had never thought of the legal profession before I went to law school. Have you had any discussions about the legal profession, or have you thought about what the legal profession is? What is a profession? If you look up the definition in the dictionary, you'll see that a profession is a group of individuals who possess special knowledge and skills and in a recognized body of learning, and who come together to apply those skills and experience for the benefit of other people. But it's more than that. Professional organizations are typically governed by some rules of ethical conduct. And if you don't abide by those rules of ethical conduct, you can no longer be a member of that professional society. Our ethical conducts are the Code of Professional Conduct. In South Dakota, our profession is essentially a self-regulating one, meaning that the members of the profession police the other members of the profession. So if you do go on to become a lawyer and are licensed to practice in South Dakota and you violate one of the rules of professional conduct, you may be called upon to answer before the Professional Conduct Committee of the State Bar Association. They will investigate the claims against you and decide whether or not they think there is something that you have done that violated the rules, and then they make a recommendation to the Supreme Court about what, if anything, should happen to you as a result of those violations. Clearly not something that you ever want to have happen to you. I'm not going to engage in an extended discussion today of those rules of professional conduct because you're going to have a chance to learn about those. I presume you all will take a class, and I know you all will take the MPRE, the Professional Multi-State Responsibility Exam, unless you're lucky enough that the new exam comes into place by then, or some new other procedure comes into place before then to do it. But you will have the opportunity to learn those things, and they are important. But here's the point that I didn't understand early on, and that I want you to understand today about those rules of professional conduct. Those rules set the minimum standards for you. Those are the things that you must do in order to remain a member in good standing. Now, I don't know about you, but I expect most of you have not lived your lives by merely accomplishing the minimum, right? I expect the fact that you're here indicates that you have expected more from yourselves throughout your life. You've probably achieved more than the minimum on almost everything you've done in your life. And I'm going to encourage you to think about those rules of professional conduct in that way and recognize that as minimums, they don't set the standard for you. They only set the minimum floor for your performance. And you should expect more from yourself, and you should deliver more for your clients. The job that you're considering undertaking, becoming a member of the legal profession, is important work. The things that you will do for your clients are important to them. It's vital to our system that you understand your role as a member of our society, because you are going to become the guardians of the rule of law. Now, that's a phrase you hear quite often, right? The rule of law. And have you, like with the term profession, have you stopped to think about what the rule of law is? Usually nowadays we hear it from politicians and sometimes lawyers, and they're talking about the idea that no one is above the law, which is certainly an important aspect of the rule of law. But again, if you look at the definition or look up a definition of the rule of law, what you'll find is that the rule of law is the idea that we have identified principles or rules that we apply and or procedures that we apply to try to regulate power, to make sure that power is not exercised arbitrarily, that people who exercise power are restrained in the way that they use that power, and that we have a method of doing that that is not based on arbitrary decision making, is not based on the strength of the person holding the power, but is based on a rule of law that follows through time. And that's what you're studying in law school, is you're starting to develop for yourself an understanding of those rules. When you sit down for one of your classes and you read a case, from that case, you're supposed to derive various principles from which the court premised its decision. And most of the cases that you read in your classes are appellate cases from courts like the court that I sit upon now, where the court is applying some well-established set of principles and rules to try to help it assess whether the court that's under review has correctly applied the standards of the established law, or has rendered factual findings that are not consistent with the evidence that was presented in front of those. Those are the two things that we typically do as appellate courts. We are not sitting there trying to substitute our judgment for the court that we are reviewing, but what we're doing is checking whether those people have exercised their power consistent with those principles and standards that have been developed over the course of time. Everything we do as an appellate court is aimed at systematizing our process and the standards that we use to try to eliminate those arbitrary exercises of power. But we all have to recognize that the people who are involved in this process are human, and as such, we are imperfect, and we make mistakes sometimes. As a result, we should not give up. We are always going to do what is best to try to secure and enhance the rule of law. So despite the fact that we can't reach perfection, doesn't mean that we don't attempt to attain it. You're all probably close enough to the decision about what got you to law school, but I ask you to think to yourself about what it is that made you decide that you wanted to become a lawyer. Was it, I don't know what to do next? That's legitimate. That happens sometimes, but I suspect if you're anything like me, you probably had in mind that lawyers are leaders and that you wanted to be a leader. Your perception that lawyers are respected by the society, and your idea that you would like to be respected also. And I suggest to you that simply by virtue of your graduation from law school, you're going to be recognized as a leader in your community. Whether you decide to practice law or not, but the fact that you're a lawyer is going to result in you being invited to take on leadership roles. You're going to be asked to be part of councils and committees and commissions. I guarantee you, you will be asked to run for office at some point in time. And I encourage you, if you have the time and the inclination, you should do that. It's important. When he read my outline, I'm not really a committee guy, but you notice I served on a lot of committees over the course of time. I didn't naturally feel like I was a person that was driven to be on committees, but I got asked because of the leadership role that you take as a member of our profession to perform on committees, and I never turned down a request from the governor or the chief justice or any of those individuals, because it's an important part of our responsibility as a member of the legal profession to take on those responsibilities and to help develop the law. So I encourage you to do those things too. We have a handful of lawyers in South Dakota who take time out of their very busy schedules to become members of our legislature, and they help develop the law in that way. And so I encourage you to do those things too. But what I want you to do is to recognize that the role that you are undertaking is a role which will lead you to exercise power. You've already started to do that, whether you realize it or not. Your family and your friends already look at you differently simply because you're in law school. I expect you can nod your heads if it's true, but you've already been asked questions when you go home for your breaks. People want to know what you already know, and you're only halfway through your first year or halfway through your second year. But people will expect you to be a source of knowledge for them, and they will ask you questions. So I'm sure all of you, maybe not, I may be speaking because I'm a little bit older, but you remember Spider-Man and the advice that Uncle Ben gives to Peter Parker, right? With great power comes great responsibility. Thank you. Power carries with it a moral obligation for you to use that power both thoughtfully and carefully. Today, I want to encourage you to start to formulate principles that are going to guide you in the exercise of your power. In my mind, one of the greatest threats to the rule of law arises when people undertake the exercise of power. They take on leadership positions without establishing core principles to guide them in the exercise of that power. In the worst case, that happens when people seek power solely because they want to have power and they don't really have anything other than their individual ambition that drives them for that. I'm realistic. I understand that ambition drives us all, and that ambition can put good people in place. It can also put bad people in place. And part of what distinguishes between a good leader and a bad leader is a person, in my mind at least, is a person who has concepts in their mind about why they want to be a leader and how they want to exercise that power. So I encourage you to think about the power that you will hold as a leader in your community, as a member of the legal profession, as a lawyer, and start thinking about how you want to exercise that power. Because, as we all know, another axiom that we can all repeat to is power corrupts. When you are placed in a position of power, you have the opportunity to misuse that power. And you are less likely to misuse the power if you've thought about it, if you've thought about why you want power, how you want to use the power, and the limits of that power, and how you should confine yourself to those things. So now is a great time for you to start thinking about that, because your role is growing as a leader in your community. It's a good time for you to start thinking about lane markers. Think about the things that you're willing to do, the things that you're not willing to do as a lawyer. I used to frequently talk to my law clerks and use as examples the more recent cases of ethical violations that came before the court. And you can pull those up. You can, whenever there's an ethical case that comes up where some lawyer has done something that's inappropriate, you can pull those up and you can look at them, and we publish those decisions to help educate the bar too about mistakes that people have made. And when you will read those cases, you'll find that there tend to be sort of three main areas, at least in my mind, that get young lawyers or lawyers in trouble in their practice of law. First one is mishandling money. That happens quite often. We've tried to deal with that because we have various procedures in place to try to make sure that you don't have the temptation to misuse your client's money, but it does still get people in trouble. Another problem that frequently comes up is simply not getting work done for clients. That's probably the most common complaint that's filed against an attorney. And that's a person who has probably bitten off more than they can chew in their practice. They have continued to take on clients, they continue to take on work, and they're unable to complete all of that work. And so by recognizing that that's a problem that people get into, you can help avoid that problem as you engage in the law practice. And the third one that I see most commonly is conflicts of interest. People doing things in their practice that they should not be doing because it involves them personally. The example that I would frequently raise with my clients is, or I should say with my law clerks over the years, was talking about, there was a case at one point that came up that involved an attorney who had misused his client's money. And very briefly, sort of the scenario was that an elderly client had placed money into the attorney's care. The attorney had placed the money into his trust account. And then the elderly client had not moved forward with her plans. And so the attorney had this money in the trust account for a long period of time. And the end of the month came along and it was time to make payroll. And the attorney didn't have enough money in their own private account. And so they borrowed from the client's money. And they fully intended to pay it back as soon as they got some bills paid and got some client bills paid. And of course, they probably did that too, if I recall the facts of the case correctly. But then the next month comes and the same problem arises, and they still have their client's money. And so they borrow a little bit more, and eventually got to the point where they were unable to pay it back immediately. And now the bill comes due because the client suddenly does want to take action, but now they no longer have their client's money or the full amount of their client's money. And I mentioned that example because I think it's a good example where you think about when I lay it out to you, you say, well, I would never do that, right? I would never take my client's money. And I'm sure that lawyer thought that way too. I would never take my client's money, but allowed himself to get into a position, probably because he hadn't really thought about it that way, and allowed himself to get in a position that ended up getting him sanctioned by the Bar Association. I don't want that to happen to you. You don't want that to happen to you. So it's a good time for you to start thinking about, and a good way to do it is by paying attention to the cases as they come out. Maybe looking up cases too about what got lawyers into trouble, paying attention to what's happening in society and how lawyers are misusing their power to help you try to avoid those same problems. Consciously draw lines now before the pressure of your practice and the presence of your power can influence the decision-making that you make. Once you've identified lines for yourself, you're more likely to recognize them if you come up to them. You're more likely not to step across them. If you don't think about these things in advance, about how you're going to practice what you're willing to do and what you're not willing to do as a lawyer, then you are more likely to find yourself on the wrong side of the line. And you may find it very difficult to get yourself back across that ethical barrier. So I like to think about it as at this point in your life, thinking about, and I still do it for myself, is thinking about the way I want the world to think about me as a professional. Think about drawing a picture of yourself the way you want the world to see you. And you draw the lines that depict that person that you want the world to see, that professional that you want the world to perceive. Now, you don't have control over all of that. Things will happen in the practice of your law that you don't have control over, and it may make the picture different than the way that you envisioned it. But if you have those broad outlines in place, you will get a picture that looks something like what you hope people will see. So I talked to you a little bit about power. I talked to you about the nature of the rule of law. I talked to you about our legal profession and the nature of it, and the idea that our rules of professional conduct establish minimum standards for you to guide you in your professional life. I've also suggested that you contemplate each of those concepts, formulate your own lines and rules, and to help you navigate your exercise of your power. Now, I also want to encourage you to consider your responsibilities as members of our legal profession. To whom much is given, much is required. You've all worked very hard to get where you are today, but you've also been blessed with the opportunity to use your intellect and talent to get here. You have obligations to those who came before you and to those who will come after you. You have the responsibility to your community to use the knowledge that you gain and the training that you receive to try to advance the rule of law. As a member of our legal profession, you also have obligations to the law, to the legal profession, and to the legal system. And I want to talk with you briefly about each of those things. Every year, the Young Lawyers Association of the Bar holds a statewide swearing-in ceremony. We just did it last week in the Capitol building. And not anyone who wants to participate that's a new young lawyer that's going to be sworn in can come and participate in it. The Chief Justice administers the oath. Your family and your friends are there. And it's a great occasion to come, and I encourage you all when the time comes for you to participate in that, even if you've already been sworn in, because like here it is October, and they found out the bar results, I think, in late August. And so a lot of you will want to be practicing before that. You can still attend the statewide swearing-in ceremony. But one of the things that always strikes me as the Chief Justice administers the oath, it's really a complicated oath. I provided you with copies here today. But one of the things that always strikes me as the new lawyers are reading the oath is it's almost always apparent to me that it's the first time they've ever looked at it. They've never had a chance to think about it or read it. So that's why I brought you copies. Part of the reason I brought you copies today, because I think the oath is really helpful. It outlines some of those aspirational goals that I've been talking to you about here today. And so I would encourage you to read through it, think about the things that are embodied in it, and of course, take it with you today. So like all oaths, it starts with a promise to support and defend the Constitution of the United States and the Constitution of the state of South Dakota. But then in the third stanza, you promise that you will not advance any unjust suit or defense except as honestly debatable under the law of the land. When you take that oath, you're agreeing to become a steward of the law. You defend it by arguing for continuity and by not advancing positions that you know to be contrary to our history and traditions. With that idea in mind, I ask you to pay attention to what's happening outside in the world. Pay attention to the cases and the theories that lawyers across the nation are advancing on behalf of their clients. I suggest that if you critically assess many of those cases, I'm pretty confident that you're going to identify, with your new knowledge and training, you're going to identify theories and causes that are wholly inconsistent with maintaining the rule of law. And I ask you, when you see those, what are you going to do about it? Right now, you don't feel any obligation to do about that, but when you swear that oath to become a steward of the law, I suggest you have some obligation to do more than sit by and watch it happen. In most of those cases, even when you identify something that you know is inappropriate, there's already going to be some lawyers that are defending that case, representing the other side and advocating that before the court. And hopefully they're doing a great job. And I'm not suggesting that you have to horn in and try to go in and take over a case or anything like that. But we don't defend the law only in courtrooms. We also defend the law in our daily interactions with people. You as a leader in your community, you can help to defend the law by bridging any gap of understanding that there may be. The lay public hasn't had the training experience that you've had, and they don't necessarily understand why courts do what they do. And when someone tells them that it's wrong what the court did, unless someone explains it to them, they don't have any reason to disbelieve that. And there are a lot of people doing that these days that challenge the decisions of courts, not based upon the actual merits of the decision, but on some other principles or some other ideas in their mind about how courts operate. In the oath that I have provided you, you also promise that you're going to use the means that only are consistent with truth and honor, and to abstain from all offensive personality. I've spent some time explaining to you that lawyers are perceived to be leaders, but I also want to remind you that lawyers are not always perceived positively. We all know Shakespeare's quote from Henry VI, right? The first thing we do, let's kill all the lawyers, right? Anyone out there, can you recite an architect joke for me? I don't know any architect jokes. They just don't roll off your tongue. Do you know any lawyer jokes? Okay. And why is that? You know, there are so many jokes about lawyers. Now, I'm not suggesting that you should get bridled up whenever someone tells a lawyer joke, or that you should castigate them for telling a lawyer joke. But I do want you to think about the nature of lawyer jokes. Most of them are negative about lawyers, right there. And it's about a perception of lawyers. And it's about a perpetuation of the perception of lawyers. And you need to recognize that another old axiom, that behind every joke, there's a kernel of truth. There's a grain of truth behind every joke. When someone kids about something, there's some truth behind it. I'm simply suggesting to you that you should recognize that there is this negative perception of lawyers, and you should consider how your interactions with others will perpetuate that negative perception. I've had the opportunity in my career to observe law practice in New York, New Jersey, Pennsylvania, Colorado, and South Dakota. And I can tell you that it's different in those other states than it is in South Dakota. They each have their own character of practice, but it's very different here in South Dakota. And a large part of what it is about how lawyers treat each other and how they prosecute their cases. And I think that, at least in my perception, in most other states, lawyers are viewed more negatively than the members of the legal profession in South Dakota. South Dakotans still think well of lawyers because they interact with their own lawyer, and less negativity has come out there, but we're not immune from it. And we have to guard against the negative perceptions that intrude upon us from other places. As I said, in some of the other states, I've observed in practice, lawyers mistreating each other, being disrespectful to each other, talking poorly about the courts and about their colleagues to their clients and to the public and in the news. And why would the public respect you as a member of a profession if you can't respect yourselves, if you can't treat each other with respect? So I encourage you to think about that. As South Dakotans, we have this tremendous advantage. South Dakota is a small state. We were just having a discussion a little bit earlier about people that we ran into over the weekend that happen to know each other because we're in a small state. Our bar is even smaller. As a student at USD, you already have a huge advantage. You will know 2 classes in front of you. You will know 2 classes behind you. You'll know 5 years worth of lawyers. If you extend yourself at all, you'll have the opportunity to make the acquaintance of five different years worth of lawyers out there. So when you go out and practice, you're not on your own. You already have people that you've shared pizza with, maybe had a drink with, maybe shared some other formative experience with, moot courts or law review or something else that a study group. Those people are important for you, and you have that advantage that doesn't happen in states like New York and Pennsylvania, and even in Colorado. The bar is just too large. And part of what happens in those states is that you expect that I will never see this lawyer again, so I don't have to treat them with respect. That's not true in South Dakota. Every lawyer that you practice with, every lawyer that every judge that you appear in front of, you will see again. They will recognize you, and you will have an opportunity. They will have an opportunity to treat you the way you treated them. So treat people with respect. I understand we don't always get along, but how you treat your colleagues, starting right now and in the future, is going to shape the nature of your practice and your life in the law. You can be zealous for your clients. You're obligated to be zealous for your clients. But you also can be kind when it's within your power to be kind. So I encourage you to do that. I'm reminded of a time several years ago where a young attorney, very young attorney, second year out of law school, requested a continuance on a case because his son had developed leukemia and he wanted to attend the first chemotherapy session for his son. The opposing attorney, the attorney on the other side, opposed the continuance request. The attorney was only asking for a couple of days. He just wanted to be there for his son. I granted the continuance request. I got it back on the calendar within 3 days. It did not cost the opposing counsel or his clients anything. Nothing real in the terms of their case. What it did cost the opposing lawyer is at least some of my respect. And it did cost him his relationship with his colleague. Don't be that person. If it's within your power to grant a continuance, do that. If it's within your power to help that's consistent with your obligations to your client, you should do that. There are times when clients are insistent and say, no, you cannot continue this case. And I've had that happen many times, and I've had lawyers come before me and they'll say very tactfully, my client has asked me to oppose this continuance. And the message is clear. Your client has asked you to do that, and you've done what your client asked. No more need be said, but in the same, you've fulfilled your obligation to your client by raising that concern to the court, but you've also not put yourself in a position where you've denied someone a kindness. If you haven't realized it already, you've already begun to develop your professional reputation. The reputation that you form with each other, the way you treat each other here and in law school, is already affecting the way people think about you. The law professors, the dean, your fellow students, these things are already making a difference about the way your practice is going to be. Lastly, I want to talk to you about your obligations, as I see them, at least, to the legal system. In 1832, the United States Supreme Court issued a decision in Worcester versus Georgia, and they struck down a Georgia law that attempted to regulate the coming and going of white people on the Cherokee lands. And although the concept of judicial review had been established in Marbury versus Madison over 30 years earlier, it was not the effectiveness of judicial review was entirely, and still is to this day, entirely premised on the willingness of the other branches of government and of the people to accept the decisions of the Supreme Court. President Andrew Johnson, in that particular instance, was unwilling to do so. I'm sure you probably know the quote. He refused to respect the decision of the court and said something to the effect that Justice Marshall has made his decision, now let him enforce it. And as you all know, we don't have armies to enforce our decisions. We don't have police to go out and enforce our decisions. We rely upon the respect of the public, members of the judiciary, members of the legal profession. We rely upon the respect of the public to enforce our decisions. Alexander Hamilton identified this problem for us over 200 years ago in Federalist number 48. He said, "The judiciary is beyond comparison the weakest of the three departments of power. It can never attack with success either of the other two. It has no influence over either the sword or the purse, no direction either of the strength or the wealth of society, and can take no active resolution whatsoever. It may truly be said to have neither force nor will, but merely judgment." Others have described the judiciary as the least dangerous branch for those reasons. You know, I suppose it's human nature for us to reflect on the past and remember the good old days. And there's always this tendency that we have to perceive the present as the most dangerous or the most challenging of times. You know, we're about to have an election, and you hear at every election that this is the most important election. I'm not going to talk to you about elections, but I am going to talk to you about where we are as a legal profession. I think about that when I tell you that I'm mindful of that danger that we perceive everything as horrible, but I'm going to tell you that in my perception, the judicial system's credibility is at its highest risk right now as it's ever been. And I'm going to talk to you a little bit about why I think that's true. I think there's this growing perception by the general public that judges are political actors, that they are not guided by the law or by principles or by logic, but that they are guided by political preferences. And I ask you to think about what drives that perception. And I think because we know that perception is out there, we have to ask ourselves whether that perception is in fact accurate. Oliver Wendell Holmes observed in 1881 in the common law, he said, "The life of the law has not been logic, it has been experience. The law embodies the story of the nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics." Whenever I think of that quote, I'm reminded that the experiences in our life shape us all. We should not be surprised to learn that a lawyer who spent their entire career as a prosecutor who then becomes a judge, will have a judicial philosophy that's shaped by their experiences in the practice of law. The same is true for a lawyer who was a public defender or did commercial litigation or transactional work. You are shaped by the experiences in your life. If the law were a book of mathematics, we could simply look up the formula that resolves our case, and we would all come to the same conclusion every time. In some instances, we can do that. We can often derive principles from our statutes or from our decisional law, and with certainty and with ease, we can resolve cases because we've established those principles in advance. But there are also many other times when it's not so straightforward. In those circumstances, we have to engage in a good faith search for a resolution that is consistent with our existing law and that will not wreak havoc with our future resolution of similar cases. Now, as much as I'd like to pretend, or maybe we'd all like to pretend, that we're engaged in a science, we're not. What we're attempting to do is exercise logic as influenced by the experiences in our life, and we should recognize that that's what judges do. So what should we expect from the judiciary? I think we should expect them to understand that they have implicit biases that arise from their life experiences. We should expect them to engage in that good faith effort to resolve the disputes that come before them based on principles and logic. Something must have fallen off. Okay. So it shocked me a little bit. So again, we should expect them to engage in good faith efforts to resolve the disputes that come before them. And we should expect that their decisions be based upon principles and logic. But because we are all human, we cannot expect perfection. In part, that's why we have appellate review, to guard against those human imperfections. But even appellate review must end at some point, and it is not in itself immune from human frailties. Judges will make mistakes. As a member of this profession, with a duty to defend the law, it's appropriate for you to identify those errors and to seek their correction. But I suggest to you that you must also defend the judiciary when its decisions are based on good faith efforts to resolve a dispute based on legal principles and logic. When I read the newspapers or watch the news, I'm deeply troubled by how the judiciary is depicted. A story describing a judicial decision often opens with some description of the judge or the justice as a conservative or a liberal or a Republican appointed or a Democrat appointed. What follows is usually some cursory explanation about the result of the ruling, followed by some description from the losing party of the egregious manner in which the court resolved the case. Every one of these reports reinforces the narrative that I believe is deeply harmful to the legitimacy of the judiciary. The narrative is the idea that judges are political actors and that their decisions are driven by their political decisions. Now, again, I'm not naive enough to say to you that no court has ever made a decision driven by their political preferences. We know that happens, nor am I saying that we should accept that when it happens. But I suggest to you that those are the rare exceptions to the rule. And the rule is that judges make their decisions based on the principles that you're learning here in law school. And the nice part about it is you don't have to take my word for it, is you're learning those principles. And when you receive a decision from a court, you can look at it and you can say, did that judge apply the principles that I learned in law school? Or are the principles that the judge applied consistent with the law as it exists in our state or in our nation? And if it is a good faith effort to accomplish that, you should defend that decision, even if it's against you, okay? And when someone says something different, you shouldn't stand by mute and let someone challenge that decision because the judge was appointed by a Republican governor or the judge was appointed by a Democratic president. You should defend the decision if the decision is based on logic and principle and consistent with your understanding of the law. Don't reinforce that perception that judges are political actors, and don't stand mute when you hear other people do that. When the public's perception of the judiciary is undermined, it enables political leaders to adopt President Jackson's point of view and ignore court decisions. And when that happens, the rule of law doesn't exist anymore. And then the power is exercised by the most powerful in the manner that they wish to do. Now, I know you're probably saying to yourself, I'm a 1L. What does he expect from me? I'm a 2. I haven't even passed the bar yet. I'm not a lawyer. What does he want from me? So I'm going to tell you a few ideas. What I hope for you will do after our discussion here today is that you'll understand that by becoming a lawyer, you're going to develop the power to influence people. It's already happening, as we've talked about. You've already started to accumulate the power. People treat you with respect simply because you're in law school. They are going to treat you with even more respect once you become a member of the legal profession. They will look up to you. They will ask you your opinion. They will respect your opinion. I want you to think about the message that you convey through your words and your actions as a member of our profession. Again, remember Uncle Ben's advice to Spider-Man. With great power comes great responsibility. Think about the nature of the power that you're going to wield. Think about how you intend to use it. And think about how you want the world to see you and your profession. Start drawing those lines today to help you ensure that the picture that the world sees is the one that you have imagined in your mind. And I thank you for listening.
Okay, so I think we have time for 2 quick questions. I know people have to get to class, but we still have a little bit of time. Alec and Sydney are going to go around, and they're going to have 2 mics for you to ask your question.
It took way longer than I thought I was going to do. I'm sorry. I meant to have more question time. Questions? Anyone? Not restricted to today's topic. Okay. I think we would like to get a mic so that the people who might hear it on the camera.
Justice Myren, back in the days of your law school experience, what did you find to be the most, what was the best learning experience? Was it, the classes, like where did you learn the most? And I guess if you have some wisdom, some nuggets that we can take.
Yeah, in law school. So I think we have a professor here, and I don't mean to be rude, but you're going to learn a lot more out of law school. And I think he'll say that too. You'll learn a lot more in the practice of law than they can stuff into your head in 3 years, okay? So do not continue or do not stop learning just because you finish law school. That's number one. But while you're in law school, I think the most important thing is to open yourself to other opportunities. You have speakers come in to talk to you. You have opportunities to see other things. You have the opportunity to expose yourself to other things besides the lectures that you have signed up to take those opportunities. Because as soon as you start practicing in Sioux Falls or Wakanda or Fort Pierre, those opportunities aren't available to you nearly as easily. And so, yeah, open yourself, open your mind. You may have an idea in your head about what you think you're going to do in the practice of law. And I'm going to tell you, fate has a different idea in mind for you probably. I never expected to be a judge. I never expected to have anything to do with criminal law. I didn't think about that in law school. I mean, obviously we took the classes, but if I had known about what would happen in my life and career, I probably would have studied some different things too, And so but you do have the opportunity to play catch up in life too as those things happen, and you will. Other questions? I hope that answers.
Hi, Justice Myren. Legal careers are known for pretty high highs and low lows. So what would you say you did to sustain your legal career during some of the more difficult times?
It's part of what I talked about today. It's about drawing lines. It's about sitting down and assessing for yourself what's important in life. What happens to a lot of people is, you go out into law practice and you're trying to be successful. and you're taking on clients, and as we talked about, maybe taking on more clients than you can successfully deal with, and you're creating conflicts in your life that make it difficult for you to fulfill all those things. It's really important to have a focus on what's important in life. One of the things I'm often asked, why I used to practice law in Denver. Why did you leave Denver? And I tell the story. I came to work one day and I realized none of the partners in my law firm were married to their first spouse. Not a single one. And I said to myself, that's not me. If I continue on the path that I'm on, and I could see it happening, I could see that. And so I had it firmly in my mind what was important to me, and that was my wife, my family. We didn't have kids yet, but I was hopeful. And so having in mind a focus on what's important for you so that you can, as I described earlier, know when you come to a line that you don't want to cross. If you've thought about those things in advance, you'll recognize it when you get there.